to discuss potential limitations on what the former president might publicly divulge about evidence acquired in the probe. Attorneys from both sides have been instructed by the judge in Donald Trump's election lawsuit to meet in court. Judge Tanya Chutkan had commanded the special counsel's office and Trump's attorneys to choose a date for a hearing on or before Friday in a dispute over conflicting protective order plans that would allow the government to begin providing material to Trump's team. John Lauro and Todd Blanche, Trump's attorneys, argue that the prosecution's proposed order is overbroad and may partially silence their client, the front-runner for the Republican nomination. In response, the federal government argued in a court document that Trump's suggested changes to the injunction were designed to allow him to try this case in the media rather than in the courtroom. Before Chutkan delivered her judgment, Trump claimed that the government's proposed injunction violated his First Amendment rights during a rally in New Hampshire. After the special counsel's office stated in a joint filing earlier on Tuesday that it was available for a hearing on Wednesday, Thursday, or Friday, Chutkan set the hearing in motion. Trump's legal team claimed that Thursday was not a favorable day because Blanche was scheduled to appear in federal court in Florida on Friday for Trump's arraignment in a separate case brought by Smith's office, which claimed that Trump handled national security documents improperly and attempted to cover it up. Instead, the defense requested that the hearing take place on Monday or Tuesday of the next week, but it did not elaborate on why it had problems with either this Wednesday or Friday other than to remark that it had lost Friday as an option. Chutkan issued a brief decision late on Tuesday directing both parties to come before her on Friday at 11 a.m. ET. Separately, Trump's attorneys filed a motion asking that the 25 days between Trump's first court appearance on Thursday and the hearing scheduled for August 28 not count towards the Speedy Trial Act's computation of time. They claimed the proposed exclusion is warranted by the complexity of this matter, including the substantial volume of discovery and novel questions of fact and law. They referenced a federal provision that permits the court to omit certain periods of delay when it computes time restrictions to start a trial. The ends of justice are best served by a speedy trial, the prosecution claimed, adding that they will react more specifically after considering Trump's motion.